Excuse me.
Thanks so much for joining us today. I am Sadie Kiran and I am with Hub Cycling, and I am so thrilled to be hosting two wonderful lawyers from Richard Buell Sutton. So I'll just start off by doing a little land acknowledgement. We are gathered virtually from probably many different lands. I'm on the land of the Musqueam, Tsleil-Waututh, and Squamish peoples who have since time immemorial have been the stewards of the land and waters upon which we live, work, and play. So I'm so excited that we have two fantastic lawyers from Richard Buell Sutton today that are going to be doing a presentation all about estate planning essentials. As you may know, it is Make a Will Week this week, which is always a good reminder about thinking what we should include in a will. And for many of us, maybe it's the first time we're thinking about it, or maybe we just want to take the next steps to update it, to make it happen. And we've got two fantastic people here who can help guide us in everything that we need to know about estate planning. So we have Kiran Dhesa, who is an associate at Richard Buell Sutton and a member of the Estate and Wealth Advisory Group. Practicing from the Surrey office, Kiran advises clients in areas of estate planning, estate administration, and committeeship applications. Kiran collaborates with clients to develop personalized estate plans that provide confidence in their future and ensures their families are well cared for, and clients value Kiran's compassionate approach to addressing their legal needs. So Kiran will be speaking first, and then we also have Arielle Lavender, who is a partner and co-leader of Richard Buell Sutton Estate and Wealth Advisory Group. Practicing from the Vancouver office, she advises clients on restructuring privately owned businesses and partnerships, personal estate and incapacity planning, trust planning and administration, estate administration, and general corporate matters. Arielle collaborates closely with clients and their advisors to develop and implement customized strategies that address their unique circumstances and achieve a broad range of personal, tax, family, and business succession objectives. And Ariel also serves as the chair of RBS's student committee. So I'll pass it over to Kieran.
Thanks, Sadie, and thank you to everyone joining us today. We're so excited to be talking about this topic. So I'm just gonna move this closer to me. Okay, so we are going to talk about the kind of different types of planning that you can do that come into place at different times during your life and after you've passed away. I'll be starting with talking about incapacity planning, and we'll talk about what happens, when you die, and Arielle will be talking about other estate planning tools. So this first slide here, estate planning timeline of documents, we'll be going over all of these documents, and you can see on the timeline how they fit in at different times during your life and after you've passed away. So I'll be kind of referring to this timeline as I go through. So, oftentimes people will ask questions, or clients ask questions about what happens, if I've had a stroke, or I can't manage my finances, if I can't manage my business assets, or I can't look after my own health care and personal care, what happens in those situations? So if you don't have a plan in place when it comes to your finances, there's actually no person who has the authority to manage your financial affairs if you become mentally incapable. So if you don't have a plan in place, and now you've lost your mental capacity, you're not necessarily out of options. There are a couple of options. So first would be a committeeship order. So this is a court order where someone can apply to be appointed to be a committee to have the authority to look after your finances. So I do this often when someone doesn't have a plan in place, and it's a lot of work. You have to get doctor's assessments. Someone has to attend personally in court to get this order. Public guardian and trustee has to be involved. It can cost a lot, $8,000 plus in legal fees and other costs like paying the doctors for their assessments, things like that. So it can really add up, and it takes a lot of time. It takes, at least 3 to 6 months to get this order. But that is one option if you don't have a plan in place, something that you didn't implement yourself. Another option would be you didn't plan, and a committeeship order is not an option, then the public guardian and trustee may look after your assets and may start making decisions on your behalf. So the public guardian and trustee is a government organization that looks after the needs of vulnerable adults. So if, again, you don't have a plan in place and someone needs to help look after your finances, the public guardian and trustee would do an assessment and figure out if there's no one else who can do it, and you're really not in a position to help yourself, then they may take over. They do charge fees for doing their job, but that would be another option. So if you don't have a plan in place when it comes to your healthcare decision making, there is legislation in BC that says who can make healthcare decisions for you, but it would only be in emergency situations. So without a plan in place, your spouse, adult children, your parents, backup siblings, just as the chart says, can make decisions for you, but only in emergency situations. It doesn't cover all types of healthcare decision making about major surgery or minor surgery, those type of things, only emergency situations. So now what can you do? How can you plan ahead? And I think, oftentimes, and it is Make a Will Week, which is really important, but I think when you're thinking about your estate plan, people often think about wills, but not necessarily about planning for incapacity of, what does happen when, you can't make your own decisions anymore. And I think that's really important because it impacts you while you're living. Your day-to-day life is impacted by who would be making these decisions for you, and do you have someone in place to make these decisions? So when it comes to financial matters, what you can do is a enduring power of attorney. And this allows you to appoint someone to make financial decisions for you that cover, your personal property, real estate, and the person you appoint can make all types of decisions on your behalf when it comes to your finances. There are some limitations. They can't, transfer assets to themselves unless you specifically would want to include that in the document. They can't change your will. Without a court order, they can't change beneficiary designations on your registered account. So there are some limitations, and you can make this document as broad or you can make it as narrow as needed depending on your circumstances. And oftentimes clients will say, well, why do I need a power of attorney when all of my assets are jointly held with my spouse? Our real estate is jointly held. Even if that's that may be the case, but if your spouse no longer has their mental capacity, without a power of attorney, you don't have authority to sign on their behalf to sell your home or refinance a mortgage or any kind of financing. So that's why having a power of attorney is very important and very useful. And then the next document here is called a representation agreement. So the representation agreement allows you to appoint someone to make all types of healthcare decisions on your behalf. So, you can name someone to make decisions when it comes to major surgery, minor surgery, where you will live, all of those type of things about your personal health care. You can appoint someone who you trust to make those decisions. And then you can also include some specific wishes if you have any. For example, some people, it's really important to them that they don't want to be kept alive on life support if doctors say there's no chance of recovery. And some people want the opposite. They want to be kept alive on life support as long as possible. But whatever your wishes are, you can include that in your representation agreement. So the person who you're appointing to make these types of decisions on your behalf would have some guidance if they're ever in that difficult situation of having to make those decisions for you. They would know what it is that you prefer. Okay, so that's a little bit about incapacity planning. So just a quick recap. Without documents in place, there's no person who has legal authority to make financial decisions for you. There are a couple of options through committeeships or public guardian and trustee, but best practice would be to have a power of attorney where you're able to name someone who you trust to make financial decisions for you. And for healthcare decision making, without a plan in place, there is an option for family members to make decisions for you, but that would be limited to emergency situations only. But you can do what's called a representation agreement to appoint someone to make all types of healthcare decisions. So now we'll talk about planning for death. So when we're talking about, planning your estate for after you pass away, the first thing you need to consider is what is in your estate. So when you pass away, everything you own and everything you owe forms part of your estate. Unfortunately, your debts don't die with you. They'll continue on and will become part of your estate. We often get, people wonder, well, what happens if you don't have a will when you pass away, and will everything end up with the government? Possibly, but most likely not. So there is legislation in BC that states who will get your assets if you don't have a will. So depending on who's in your family, so if you have a spouse and no children, your spouse gets all of your assets. If you have a spouse and children common with that spouse, then your spouse gets the first $300,000 of your estate, and the balance, 50% goes to your spouse and 50% divided equally amongst your children. And if you have a spouse and you have children, but the children are not common with the spouse, then the spouse gets the first $150,000 of your estate, and then balance goes 50% to your spouse, 50% equally amongst your children. And if you have children, no spouse, then everything divided equally amongst your kids. And if any one of your children had passed away and they have their own children, that child's share would go to your grandchildren. And well, what happens? You have no spouse, no children, and no grandchildren. Then it goes to your estate would go to your parents if you have parents. If you don't have your parents, then to your siblings. If no siblings, then to your nieces and nephews. So it goes on to 5 degrees of relationships. After that point, then it does go to the government. Okay, so some people hear that and think, well, why should I do a will? Because that actually covers, who I'd want my assets to go to. If I didn't have a will, it'd still go to the people I want it to go to. There's many other reasons to consider having a will. So, it gives you control. When you do your will, you get to name an executor. So the executor is the person who will manage everything for your estate after you pass away. And it's a really not a good job, it's a really big job, and it's actually not a fun job at all. It's a lot of responsibility. The person who is the executor will have to make sure all of your final debts are paid, your income taxes are filed. They'll be responsible to, liquidate or gather your assets to make sure that they can be distributed to the beneficiaries. And they're responsible to all of the beneficiaries. They're an employee of your estate. So it's a really big job, and you want to pick the right person to do that job. And if you have minor children, your will allows you to appoint a guardian for those minor children. If you don't have a will and you passed away with any minor children, then, I'm sure lots of people feel like their family members or friends would step up and look after your children, but they would have to get a court order to do so without having a guardian named in a will, which takes a lot of time and costs a lot more to do. And in your will, you can choose additional beneficiaries in addition to your spouse and children. So if you do want your estate to maybe majority go to your spouse and children, you may have some charitable donations that you'd like to make. You can include cash gifts to any charities. You can also include a fail-safe beneficiary in the unlikely event something happens to your spouse and children, who your assets would go to. You may not want it going to your siblings or nieces and nephews. I worked on an estate where someone did pass away without a will, and they had a cousin who was very close to them and looked after this person for many years. But because he passed away without a will, his estate got divided amongst 18 cousins, majority of who he had never met, and his cousin, who was always close with him and looked after him, had to share his estate with all these people who, called me very often asking when they were getting their share, although they had never met this person. So it does give you the ability to avoid that situation of your estate perhaps ending up with someone you don't want it to go to, or maybe don't even know. And then you can choose when beneficiaries will receive the capital of your estate. So, sometimes you may have someone in your life, whether they are a minor or maybe a person receiving provincial disability benefits, or maybe just a person who is not good at managing money. You may want to have some control over how and when those people receive assets from your estate. And that's what you can do there is create a testamentary trust for those people. So a testamentary trust allows you to allocate the beneficiary's assets to the trust and name a trustee to manage the funds for that beneficiary and include terms about when and how the assets would be distributed from the trust. For a minor, for example, in BC, you have to be at least 19 years old to receive an inheritance. Oftentimes people think 19 is much too young. So in that case, you could create a trust in the will for that beneficiary to say, for example, hold the assets in trust until they're 30 years old. And while the assets are being held in trust for that beneficiary, you can say how and when they can be used until they're released to age 30. So you can say it can be used maybe for education, to buy real estate. It can be very discretionary, and the trustee can use it as they think appropriate, or it can be very specific and used in limited circumstances until that beneficiary reaches age 30. If you don't have a will and there's a minor beneficiary who receives an inheritance, their share would be held by the public guardian and trustee until that person reaches age 19. And when they reach age 19, the assets would be given to that person. So by having a will, it gives you control to change that age, say how the funds are going to be used. And in the case of other beneficiaries, like I mentioned, someone who may be receiving a provincial disability benefit, receiving a large inheritance could claw back or take away their provincial disability pension. Whereas if their inheritance is put into a trust, it can be managed by the trustee, as long as there's specific terms included that won't make that inheritance be part of their income when determining if they're eligible for disability benefits. Sorry.
Oh, okay.
Oh, I have
One more?
one more, yeah. So just, quick summary here. Lots of benefits of having a will. You get to appoint someone you trust and feel be able to look after your estate. You can determine how the beneficiaries receive their funds. You get to pick the beneficiaries and you can be very specific with how the estate is divided in terms of percentages and dollar values. And then next here, so potential issues with wills. So having a will is very helpful, for a number of reasons that we just went through. But after someone passes away, and the executor is wanting to deal with your assets, whether it's real estate or maybe assets in a bank, those institutions worry that, is this will that the executor is bringing to us truly your last will? That how do they know that the executor hasn't made a will and brought it to them? So they want the executor to prove the will. And to prove the will, they have to apply for probate. So probate is a process where the executor has to take a number of steps and make a court application to prove to the court that they are authorized to act under the will and this is truly your last will and it's a valid will. So probate from that perspective is good. It eliminates fraud when it comes to wills, but it is a lengthy process. So until a grant of probate is issued, the executor cannot deal with majority of your assets, or at least making distribution of majority of your assets. Arielle will kind of talk a little bit more about what assets require probate and which ones can potentially bypass probate. But assets that are passing through your will likely need to go through probate. So like I said, it's good in terms of that, prevents fraud. But one of the things the executor has to do when making the probate application is provide a list of all your assets to the court. And then the court calculates probate fees on the total value of your estate. So it's about 1.4% or 14,000 for every $1 million that's in your estate. Those probate fees have to be paid to the court before a grant of probate can be issued to the executor. And until a grant of probate is issued to the executor can't, sell your real estate or close out some of your bank accounts. And because these documents are being filed with the court, they become a public record, so your privacy is compromised. So all of your asset listing, anyone who knows how to view court records could pull it up and find out what you had in your estate. And wills variation. So BC is one of the unique provinces that allows your spouse and a child, including a independent adult child, to apply to vary your will within 180 days of probate if they felt they weren't left a fair share of your estate. And child does include your biological and adopted children. It does not include stepchildren. So when someone is applying to vary your will, it will increase the legal fees. No distributions can generally be made, so it'll freeze the assets of the estate. And then there's uncertainty that your wishes may not govern how your assets are distributed. So when you're doing your will, you may not want to include one of your children or a spouse for any reason in your estate. But that child or spouse then would have a right after you pass away to apply to vary your will, and it will tie up the estate. And Arielle will talk a little bit more about how to keep some assets out of your estate and alternate options. But so I won't get into that. So yeah, she'll go over that next.
Yeah. Perfect. Thanks, Kiran. So that actually sets the scene really well for some of the alternate planning that we'll talk about next, including some will substitutes. So a lot of the planning that we do surrounds minimizing exposure to probate fees as well as potential exposure to wills variation. So it's a couple of unique issues to BC certainly, but something that we spend and clients spend a lot of time trying to plan around. So a few other sort of options and will substitutes that we'll talk about next include beneficiary designations, joint tenancy of assets, as well as inter vivos trusts or trusts that you set up during your lifetime, which is a little bit different than the testamentary trusts that Kiran mentioned just before, which are trusts that you set up in your will and only take effect when you pass away. So first, beneficiary designations are such a great and often overlooked planning tool. So if you've got an RSP or a RIF or a TFSA, life insurance, you have the ability to name a designated beneficiary or beneficiaries, and oftentimes contingent beneficiaries as well. And what that means is if you've named a beneficiary, then that asset will go directly to the named beneficiary or beneficiaries when you pass away. So there's not a lot of formality to this process. It's pretty seamless. The assets can get transferred fairly quickly. It really just requires the individuals to deal with the financial institutions or whoever it is that holds that life insurance. But we're talking maybe like weeks or a couple of months to get access to these assets, if not quicker, whereas any other assets that go through your will and estate that get kind of locked up in that probate process that Kiran just touched on can take absolutely months. So not only is it a great way to keep those assets out of your will and not pay probate fees on those assets, but it also ensures that your beneficiaries get quick access to cash or assets. And oftentimes they need that money because, the bank accounts of the deceased might be locked up for a period of time. So them having access to these assets is incredibly helpful when they've got big bills to pay for the estate. For example, if they may need to dip into the funds to pay for probate fees. Having said that, though, the beneficiary of these assets, they really are the beneficiary of those funds. So they do pass outside of the estate, which means that, technically it doesn't need or they shouldn't be obligated to use those amounts to cover something like probate fees, which is an estate expense. But practically speaking, oftentimes where you do have the same people named as the beneficiary of these types of products and the beneficiary of the estate, it all sort of forms part of the same pool of assets that they can dip into. Now, if you don't name beneficiaries, then the default is that these assets will go into your estate. They will go through the will, which means that they'll get distributed according to the distribution scheme set out in the will, and they will necessarily require probate. So even if nothing else, really needed probate because perhaps the dollar values were lower than the financial institution's threshold for requiring probate, this would pull in all of the assets. So for some people, it's worth paying the probate fees because they get the certainty that, these amounts can, for example, go into testamentary trusts that are set up for a disabled child or a minor child, and that may be just fine. But for lots of people, the ability to avoid probate and probate fees is well worth, naming the beneficiaries directly. And I would just add, we've got a note at the bottom that you don't want to name minors as direct beneficiaries of these assets. If you've got a minor, it's better to just, let these assets go into the estate, or you could do a separate designation of beneficiary that can include more fulsome trusts. So we would suggest that as opposed to naming the minor directly, because as Kiran touched on, you really don't want minors under the age of 19 here in BC to get any assets directly. Okay, so joint tenancy. So joint tenants are, or joint assets, I should say, are one of those planning tools that I think are often seen as quite simple and it's quite common to add someone as a joint owner of an asset, but it is full of potential traps. So just to cover what is a joint asset. So a joint asset is an asset that you own together with one or more people. And one of the sort of inheritance mechanisms that's built into just a true joint asset is that the asset will belong to the last surviving joint owner. So if you just think of a house that's owned jointly by spouses, when the first spouse dies, the house will go automatically to the surviving spouse. Or if it's, a parent and two kids, then it'll just go to the last survivor. And the nice thing about these true joint assets is that on the first or second to die, depending on how many joint owners there are, that asset does not have to go through probate, and it doesn't have to go through, the probate fee sort of mechanism either, which is really nice. So joint assets are very effective planning tool, but it has to be implemented properly. So to make one asset joint is not necessarily going to save you the probate fees if everything else isn't structured well. So that's just something to be mindful of. When talking about joint tenancy, I think it's important to also just touch on sort of the opposite, which is tenants in common. So tenants in common is where you have sort of distinct ownership interests. So it could be, again, a husband and a wife who own a property. But in this case, they would have perhaps a 50% interest each, or maybe 40-60. The allocation can be totally different. But what really matters is that when you're tenants in common, you truly own your percentage of that asset. So let's just take the example of 60-40. And when you pass away and you own your 60%, that 60% of that property goes into your estate and into your will, so subject to probate and probate fees, and it doesn't automatically go to the other tenant in common that was holding the 40%. So that's the real big distinction between joint tenants and tenants in common, and is really important to verify that in particular real estate that you own, maybe together with someone, is set up in the way that you want. So as I mentioned, there are different types of joint assets, and they have very different results from an estate planning perspective. So, you've got the true joint asset that I mentioned, which is you and your other joint owner are the true 100% owners. You each are registered on title for that asset, so your names are on that bank account. But you also are the true owners of the funds. So if that bank account is generating interest income, the two of you are reporting that income on your tax returns. So that's just like the simplest true joint ownership. Now, there's a presumption that spouses are true joint owners when it comes to assets, but that's not the case if you own a joint asset with anyone other than a spouse. It's actually, there's a presumption of resulting trust. So if you own a bank account with a child, there's no presumption that you and the child are actually true equal joint owners. In fact, it would say that the child is just holding their interest in trust for your estate. And that distinction is really important from an estate planning perspective, because even though on the face of it, you might both be registered as joint account owners, if the true beneficial ownership is really with the parent, then the value of that asset would have to get disclosed as part of any probate process, notwithstanding that the asset looks joint on the face of it. So that's why it's very important to be very clear about what type of a joint tenancy you're creating. And so from our perspective, we always advise clients to document their intentions really clearly. Highly recommend getting a lawyer involved to help you with that, to make sure that the documentation properly reflects the type of joint tenancy interest that you're trying to create, so that when you're not here to be able to explain the ownership structure, you've got great documentation that spells it out for you. Now, joint planning, if done well, can be great in the sense that your assets might pass to the surviving joint owner pretty seamlessly, or might avoid probate and paying probate fees. But there are some downsides and some potential big downsides to adding someone on as a joint owner of an asset. So the big one I would say is you lose control. So if you now own that home together with a child, well, if you want to sell the home, you need your child to sign off on the sale documents. You would hope that they would play ball and do what they need to do to help you, but the reality is you now have somebody else that has some kind of an interest in that property. So it just means that you don't have total control over that asset anymore. So the second point is just what I mentioned earlier, the idea of presumption of resulting trust if anyone other than your spouse owns an asset jointly with you. So, it may be that you add someone on as a joint owner, but ultimately the asset doesn't go in the way that you had intended it to, because you created, a different kind of joint asset than what you had really intended to do. The other thing is that now that you've got another owner on registered title for this asset, it opens up the asset to claims of creditors, including spousal claims. So, if your child is an entrepreneur and they've got business interests, it might be really risky adding them as a joint owner of one of your assets, because if a creditor goes after your child, they're going to go after any asset that your child is attached to. And they can rely on sort of those public documents. So if your home is registered jointly with your child, a creditor can rely on that as just like a true joint tenancy. And then it's up to you on the other side to prove otherwise. So something to think about. And then the last point too is, depending on the type of joint asset that you're creating, you might have triggered taxes unintentionally. So if you're actually giving your child, for example, a true joint interest in an asset, well, you've disposed of that asset and potentially 50% of that asset, which might attract capital gains taxes. So it's a planning tool that's really, really helpful, but should not be done without proper legal and accounting advice. And so we kind of touched on sort of the advantages already, but I'll just do a little recap. So if it's a true joint tenancy, then it'll pass by right of survivorship, which helps with the administration of your estate, and it keeps certain assets out of your estate. And then in that privacy context, with Kiran had mentioned that there's lots of privacy when you do go through probate. By avoiding sort of the probate process with some of these joint assets, then you sort of maintain some privacy and you avoid having to pay probate fees, as well as potential challenges to your will. But I will say that the fact that an asset is joint does not prevent someone who's making a wills variation claim to try to say that that asset is, potentially a different type of joint asset than what you had intended. And we just had a file very recently where it was exactly that. Parent added a child as a joint owner of various accounts, and the other child who commenced a wills variation claim challenged that planning. So having the appropriate documentation to be able to back up what mom's intentions were at the time that she added one of the children on as a joint owner was really determinative, and ended up with us being able to sort of meet that challenge with success. So yeah, so just a key takeaway: best practices, get legal, and I would say also tax advice, and ensure that you've documented your intentions properly. Okay, so next up we've got inter vivos trusts. So these are really like wills substitutes is what we like to call them. So this is a trust that's created during your lifetime. So we've got alter ego trust and joint partner trusts, and they're really the same thing. It's just that an alter ego trust is a trust that you create up for your benefit alone during your lifetime, whereas a joint partner trust is set up for you and your spouse during your lifetimes. And then on your death, or on the second of the spouse's death, then you can provide how those assets are going to be distributed, much like in your will. You would name a trustee who would take the role of trustee after you pass away, and they play a very similar role as your executor would under your will. So their role is to administer the trust assets and to distribute them according to your wishes. Now, there are some eligibility requirements to be able to set up these types of trusts. So you need to be a Canadian resident for tax purposes, 65 and over, and only you and or your spouse are entitled to benefit from the trust assets during your lifetimes. These are not like inexpensive trusts to set up. So while they do come with some advantages, like the assets that form part of these trusts don't go through probate, you don't have to pay probate fees, and it helps protect these assets from wills variation claims. So it's a great planning tool if those are two of your priorities. But you also have to sort of weigh the cost benefit of setting up these trusts, the ongoing compliance, because you'll have to file tax returns every year for the trust. There may be some compliance when it comes to transferring assets into the trust, and ongoing compliance, especially if real estate forms part of the trust. The real estate rules are constantly changing both in BC and in Canada, especially if there are any sort of non-Canadians in the mix. So it's not an inexpensive or sort of simple process, but for some families, it can be really well worth either the peace of mind about knowing that they've minimized exposure to those variation claims, or just sort of being able to minimize their exposure to probate fees. And the other piece about these, which is nice, is because they're not sort of subject to the probate process, it means that it stays private. So nobody else outside of the trustee and the beneficiaries need to know what assets form part of this trust or what the values are. So that's a huge sort of incentive for a lot of families where they want to sort of maintain that level of privacy. And in particular, if you're thinking of a context where maybe you're leaving out a child or giving one child less of your overall estate, having that sort of privacy and shielding them from having access to some of that information can be really helpful from sort of the parent perspective. So a couple things to note just on the tax side of things. So when you transfer assets into these types of trusts, you get to benefit from a tax deferral. So essentially no tax is triggered on the way in, but tax will be payable when you pass away or on the second of the spouses to pass away. So much like when you pass away and you're deemed to have disposed of all of your assets at the time that you die, the trust is also deemed to have disposed of its assets when you pass away. And so taxes will be payable at the highest marginal rate. Okay, so next up, kind of switching gears a little bit, we're talking about protecting your children from family law claims, which is another area that I think is really important, in particular for parents. So we'll just kind of cover a few topics here, starting with just a little primer on sort of family law here in BC. So the Family Law Act and the Wills and Estates and Succession Act provides sort of who is considered a spouse. Sometimes people think like, oh, you have to be married in order to be a spouse, but actually common law spouses qualify just as easily. So if you've lived together in a marriage-like relationship for at least 2 years, you can be considered spouses under both pieces of legislation, which means that you have all of the rights and entitlements that come with, had you been married. So there's really no difference from a legal perspective at that point. even just determining when you become a common law spouse can be a bit of an exercise. And I think the 2 years can really creep up on people quite quickly. So let's say you are spouses and there's a separation event. So spouses generally are entitled to 50% of whatever is considered family property. And for each family, this is going to look a little bit different, but there are some specific exclusions from family property as well as specific inclusions. So we've just included a chart there at the bottom that you can go through to get an idea of what generally is included as part of sort of the family property settlement. I'll just note that, some of the exclusions on the left there, gifts and inheritances are excluded, but really it's just the initial gift or the initial amount of the inheritance that's excluded, and any increase or growth in the value of that gift or inheritance forms part of family property. So it doesn't have like a blanket exclusion. You have to be very careful about sort of how that increase in value might be treated from a family law perspective. So a lot of our planning sort of happens around protecting gifts and inheritances for that reason. So we thought we'd kind of look at this from 2 different perspectives. One, like what can the children do to protect their inheritance effectively from family law claims? And then next we'll look at what the parents can do. Because sometimes, as you'll see, we go through this slide, children don't want to sort of get into these conversations with their spouses, or maybe they're already married or common law spouses, and they feel like, that ship has sailed. But effectively, like what the children can do is come up with an agreement with their spouse, or, they can even come up with these agreements before they hit that spousal status that essentially outlines their rights and entitlements in case there is a breakdown in a relationship. And so that could cover lots of things. So for example, they could contract out of the growth of the inheritance being split 50-50. They can really cover off whatever things are priorities to them. One of our types of sort of slimmed down family law agreements is a komomi, or we like to call it a keep your mitts off my inheritance. And that's really more specific to protecting a child's inheritance or any gifts that they receive, so that even if that inheritance increases in value, that property will continue to belong to the child and will not form part of sort of the family property that gets split or shared equally in case there's a breakdown. That is generally initiated by the parents, but ultimately it would be for the child and their spouse to enter into that agreement together. Okay. And then on the other side, so what can parents do? Oops, I went too far. There we go. So really all that parents can do, which is pretty powerful, is to include trusts in their planning. So if you just take the example of a will, you can include a testamentary trust so that any inheritance going to a child is held in trust. And even if that child is, 35 years old, so the trust is not created because they're minors, it's really just to protect their inheritance from future family law claims. The other benefits of having these types of testamentary trusts, I should add, in addition to some protection from family law claims, is that it can also protect a child from creditors. It gives them flexibility and control. So you can name the child as the trustee of their own trust, which means that they control, when they make distributions from the trust. If the trust no longer makes sense, they can wind it up. But if you really want like enhanced family law protections, the child should not be the sole trustee. So either they're a co-trustee with someone else, or maybe somebody else is the trustee entirely. That really kind of depends on the family dynamics and how real a potential family law claim is for that particular family. A lot of the trusts that we set up are set up for the benefit of the child and their own children. So it gives them some income splitting opportunities. For example, they want to pay for education fees for their child, they'd be able to distribute some funds from their trust for the benefit of their child. And lastly, by having these types of trusts in place, to the extent that assets remain in that child's trust, then when they later die, those assets are protected from probate and probate fees. So it can be a great probate fee planning strategy as well. And I think that's largely it. So it's a bit of a quick rundown on all things incapacity and death planning. So maybe with that, we'll hand it back over to you, Sadie. I think we'll have a bit of time for some questions if anyone has questions.
Yeah, absolutely. Thank you so much. This was so informative and incredibly interesting. Yeah, so if anybody has any questions, please add them to the chat. We do have a couple already loaded here. So one question is, can you make a chain of power of attorneys or representatives so that if they die, there are second, third, or more fallback options?
Yeah, absolutely. And actually, we really recommend that as well. So you always want to build in backups just in case something happens to your initial executor or your attorney or your representative. And honestly, it's better bang for your buck too.
Mhm.
Like you've got your thinking cap on, you're already doing your planning, you've already got your lawyer's attention, you're already spending a little bit of money to get your planning done. So to be able to add in that extra protection of naming one backup or multiple backups, just do it. Yeah. And then you don't have to risk there being a void in decision making.
Fantastic.
Oh, no.
And the next question is, when does a will go through probate and when does it not?
Do you want to take that one?
Yeah, so whether probate is required depends on the type of assets you own at the time of your passing and how you own the assets. So, for example, if all of your assets are owned jointly with your spouse, you don't own any assets in your personal name, all of your assets would pass to your spouse as a surviving owner, and there is no need for a probate. Whereas if you own any assets that were maybe just in your personal name, for example, you had a bank account and the bank account was worth $75,000, then that bank, who may not want to take the risk of giving the asset to your spouse in accordance with a will, may require probate. Each bank has their own threshold. Typically, if assets are the total value of your estate is $25,000 or less, the banks may waive probate, but it's at their discretion. So it really depends on how you own your assets, the value of your assets, and what you own when you pass away.
Yeah, and I would just add that typically any assets that you hold with a third party will generally require probate. So financial institutions, as Kira mentioned, so non-registered investment accounts, bank accounts, depending on the asset threshold, banks will require probate. And it's really like a risk prevention mechanism for them because they don't want to take the risk that they're giving money to the wrong people. So they want that assurance that there's a grant of probate and that the will has been validated and the executor has the authority to deal with the assets. So that's sort of where they're coming from. If you own things like real estate in your personal name, that will always require probate. So part of doing sort of the holistic estate plan is for the lawyer to have a look at sort of your overall assets, what you own, how you own it, and approximate value so that they can provide you with much more targeted advice about whether or not probate would be required. So it's well worth, sometimes those intake forms can be quite long when they're asking you lots of questions about your assets, but that's sort of the rationale behind it. And it's well worth the time of sort of having that conversation so you have a clear idea of whether or not probate will be required and if there are any opportunities to minimize your exposure to probate.
And sometimes, people think assets are held jointly, and then they're not. And when you come in to do your estate plan, your lawyer will typically, review your titles and make sure all those assets are joint and remind you to check your beneficiary designations to help keep assets out of probate or see if there's any other planning opportunities.
Great. And the next question is very applicable to Hub Cycling because we're a charity. Can you briefly discuss legacy giving?
Sure. Want me to do this? Sure. Yeah, so legacy giving is a great question. The nice thing about having a will or even one of those will substitutes, like I mentioned with the alter ego trust or joint partner trust, is that if legacy giving is important to you, you can include that in those documents so that it can be, a really important component of your sort of distribution of your estate. So for some people, that looks like giving a specific cash gift to a particular charity that they support. Other times it's a percentage of the pie gets given to the charity. It really depends on how much you want to give and how much money there is available to everyone else. So that's those are a couple of options from sort of the will and will substitute planning perspective. Some clients they've set up donor advised funds and named their donor advised fund as a beneficiary of their will. So it really sort of depends on sort of who you want to benefit and how much you want to give them. There are lots of different options for structuring that. One of the things that we also talk about with our clients when it comes to incapacity planning is, if legacy giving is something that's very important to you and you're in the regular habit of giving amounts to various charities over the course of a year, and you would want your attorney to continue to be able to have that power to make those legacy gifts for you if you've lost capacity, you have to include that power in your power of attorney. Because as Kiran mentioned, the legislation around powers of attorney really limit an attorney's ability to make gifts of your assets. And the limit is very, very low. So if that's something that's important to you, you'd want to consider giving your attorney that power so that they can continue to make those charitable bequests if you've lost capacity.
Maybe I'll just do the questions a little out of order because this one's sort of following the legacy giving. So does legacy giving of property mean probate?
Yeah, probate, it doesn't necessarily matter who you're giving the asset to in your will. It still really depends on how you own the asset and what the asset is and the institution or third party's requirements for probate. There are options, Arielle talked about registered accounts. You can consider naming a charity as a beneficiary of your registered account. But in probate, it doesn't really matter who the beneficiary is necessarily.
Yeah, they're kind of two distinct issues, I'd say.
Great. And I'll also mention that legacy giving, there are some tax benefits to including charities in your will. So that's always something to consider. If you ever think of supporting charities like Hub Cycling and you want to sort of plan for the future that you might not be a part of. Okay, moving on. The next question is, if all the members of your family die altogether, does the assets automatically honor the youngest member's will?
No. So, let's just say there are 3 members of this family. If they were to all pass away together, then each of their wills would be dealt with separately. They would have distinct estates and they would all be run sort of concurrently. Having said that, there are some rules about joint assets. So if you own an asset jointly with your spouse and the two of you die in a common accident, then there are specific rules about how those joint assets are dealt with. But generally speaking, each of those members of the family would have sort of their own estate, their own will, hopefully. And if not, then they would have to go through the intestate process, but it would all sort of be sort of separate from one another.
Okay, that's good to know. And can you talk briefly about leaving assets to a disabled child?
Sure, yeah, I can. So when you're considering leaving assets to a disabled child, I mentioned there's one thing that you want to take into consideration is whether they're receiving any provincial disability benefits, and drafting your will to make sure that those benefits aren't clawed back or lost as a result of receiving the inheritance. So one planning tool is to include a testamentary trust for that beneficiary. And in order for the assets to be excluded from the income and assets of that child with a disability, the trust must be a discretionary trust, meaning the trustee has full control over how the assets are used for that beneficiary, and that beneficiary doesn't have really any say in how the assets are used, because the point is to make sure it's clear that the assets held in the trust are not a beneficiary, not an asset of that beneficiary, so it shouldn't be added towards their income and asset account. And then the trustee of that trust can use the funds held in the trust for that beneficiary's benefit in certain categories without it being impacting the disability pension. So for example, it can be used for, medical devices, upgrading someone's home to accommodate a disability. And then, there's a few other categories along with a general category to promote someone's independence. So as long as the trustee uses the funds out of the trust for those within those categories, the income and assets wouldn't go towards that person's own income and assets, and they would still continue to qualify for their disability pensions. And then You can also, the trustee and the beneficiary jointly each year can elect for that trust created under the will to be considered a qualified disability trust. So the trust will be taxed at a better rate, or essentially taxed how we are as individuals at the marginal rates, whereas many trusts are taxed at the highest marginal rates. And that's a joint election the trustee and the beneficiary make every year to qualify it as a qualified disability trust. And there's a few other benefits of having that designation for the trust as well.
Great, thank you so much. So that's all the questions that we have in the chat for now. So take a moment. If you think of another question, please feel free to add them, because I did get a private message from one of the attendees here who was curious if you had any resources, because they'd read a book called How to Laugh at Death and Taxes by Barbara Amsden. Do you have any other resources, any like other educational resources that folks can maybe look into to learn more about everything to do with estate planning?
I mean, we've got some articles on our website, which you're welcome to have a poke around, where we talk about different planning tools. So that's one easy resource. Is it maybe NIDUS?
Yeah, that's a good one.
Yeah, NIDUS, NIDUS. They've got great resources on their website as well, so you can have a Google of that.
Yeah, they have really good information, especially on incapacity planning for representation agreements and powers of attorney. So that's definitely a good place to look.
A lot of just like financial institutions or accounting firms also post articles about, you know, various topics. So there are quite a few resources out there if you were to just sort of throw it into Google. Can you think of anything else? No?
No, and
That's probably a good
we'll
place to
send out,
start.
are we sending out these slides?
Oh, yes, we can also circulate these slides if that's helpful. Maybe we could share them with, or Sadie, maybe you can help with that after.
Yeah, absolutely. I'd be happy to send them out. We do have another question here in the chat. What are the best tools for helping wealthy parents passing assets to their kids with the least amount of taxation?
Well, you know, there are two certainties in life, death and taxes. So, you know, there's a limit to what you can do to sort of avoid or minimize exposure to income tax. So, as I mentioned earlier, when you pass away, CRA deems you to have disposed of all of your assets. And so there is tax payable, generally speaking, when you pass away. When assets go from one spouse to a surviving spouse, there's a tax deferred rollover, which means that the tax won't be payable on the first spouse's death. And instead, the tax will be payable when that surviving spouse either disposes of that asset or they later die. So at some point, that tax will be payable. With kids, it's a little bit harder because you don't really get that same sort of rollover of assets. I guess part of one option is making gifts during your lifetime. So you're reducing the overall size of your estate. So when you pass away, the tax bill will be smaller. For wealthy families where the tax, I mean, and I would say that it is helpful having that conversation with your accountant while you're doing your planning so you can get a really good sense on what your potential tax bill might look like if you were to pass away tomorrow, because then that gives you sort of a baseline idea of numbers that, you know, your state will have to pay when you pass away. But one of the best tools to be able to pay for any big tax bills is life insurance. So life insurance, as I mentioned earlier, you can designate a beneficiary of that. So your estate can, or whoever the recipient is, can get quick access to cash. So that's a really good way to try to offset your tax costs, is just to get life insurance. Anything else?
I think a lot of it, just for this question, you'd have to know what are the assets that are being transferred and
Or what the tax attributes of those assets are.
because you're looking at what probate fees could be, you're looking at what potential capital gains could be for transferring during your lifetime, you're looking at potential property transfer tax when it comes to real estate. So I think you'd have to know what the assets are and then come up with a plan based off of that.
They did provide a little bit more context here. They're working on drawing down my RRSP/RRIF. So hopefully when I die, there's not much left in the RRSP, RRIF. Just wondering what other things need to get done. So they're wondering, can you explain more about how life insurance works and what are the pros and cons of that strategy?
Yeah, so you can get life insurance so that when you pass away, there's a cash amount that gets paid to your either your estate, which will cover estate taxes, or to a beneficiary, which gives them cash to sort of pay that tax up front. So lots of different options on the life insurance side. We don't do life insurance ourselves, but if you're interested, can put you in touch with life insurance advisors that can walk you through those options. So that would be the pro, is you've got access to cash and you potentially would get sort of the amount of insurance that you need in order to hopefully cover the cost of the tax bill, which is why, to Kiran's earlier point, having a clear idea of what you own and what the potential taxes are would give you a better sense of, how much life insurance you have to get. Potential con is like, that's just an added cost, right? You're paying for life insurance. There are going to be annual fees depending on the amount of the life insurance. Those fees can be, somewhat expensive. Okay, sorry, I just saw another question pop up.
Yes, so there's one more, which is please explain how and why banks take so long to recognize a POA.
Yeah, if you find the answer, let us know. Oftentimes they're just sending it to the back office in Toronto, and so there's just some bureaucracy that they have to sort of go through on their end to make sure that they are dealing with the right person. As you can imagine, there's a lot of fraud. There are a lot of people that unfortunately take advantage of others. And so from their perspective, it's really just managing their own risk and ensuring that a power of attorney is properly, well, I don't know what checks and balances they have on their side, but I imagine it's, was a power of attorney properly executed, like who, all those sort of like contextual things that are really important. But I think just anytime you're dealing with third parties, things will take longer. Yeah, unfortunately.
Yeah, I don't have much to add except, yeah, I think they just are trying their best to eliminate the possibility of fraud. Why it takes them so long to eliminate the possibility of fraud, I'm not sure, but I think that's just what they're doing on the back end.
Fantastic. Well, this is just so interesting. Now it's time. I gotta go make my will. And of course, you can always reach out to Arielle and Kiran if you need any support in that department. So I put their sort of like main bios from the RBS website up here. If we go to the next slide, I think that's also got their contact information on there.
Thank you. Thanks, Sadie.
Yeah, I can't thank you enough for sharing your knowledge. This is a really important topic and a great time for us all to consider our needs.
Well, thank you for having us, and thanks everyone for joining today. Appreciate taking the time out of your, I'm sure, very busy days.
And thank you for the questions.
Yeah, great questions.
Yeah, fantastic questions, fantastic content. I'll leave this up here for a few more minutes. Thank you for everyone. I'm seeing everyone's having their thank yous in the comments. Thank you all for joining us today. And yeah, if you have any questions on the RBS side, there's their contact information. I'll also put my contact information if you ever are thinking of including hub cycling in your will. Okay, great. Thanks so much, everyone. I will be sending out the slides and the recording to your email that you signed up with. So just wait for that. I'll probably send it out tomorrow. Great. Take care, everyone.
Bye. Thank you.
Thank you.
Bye.